I'm Legalized co-host, and I'm here to welcome everybody to Constitution Day. It's a great session today on marijuana legalization and federalism with two great professors, Professor Jonathan Adler from the law school, Professor Brannon from Stanford University. We want to appreciate both of them participating. This is a great event every year. This is probably my 7th or 8th one that I've been at. I learn a lot, and what's I think most exciting about this program is that we have students leading the effort. So congratulations and thank you to all the student work that's been put into this, and also for the faculty advisory committee. And with that, we'll go on to the show. Thank you.
Thank you, Provost Bazelak. Good afternoon, distinguished guests, faculty, students, and friends. My name is Elijah Newcomb, and I will be the Master of Ceremonies. The purpose of today's forum is to celebrate the 229th anniversary of our founding charter, the Constitution. It is an honor to welcome Professor Brannon Denning of the Cumberland School of Law at Samford University in Alabama, as well as our own Jonathan Adler of the Case Western Reserve School of Law. Professor Denning and Professor Adler, the Constitution Day Student Committee appreciates your taking time to speak and answer questions on marijuana legalization and federalism. This month's legalization of marijuana for medicinal use in Ohio, as well as the continued debates on the use of recreational marijuana, demonstrate the importance of this issue. This forum will address the application of the U.S. Constitution and the legal controversies that have arisen as a result of marijuana legalization. On this Constitution Day, these complex, fascinating, and real-world issues around marijuana rights perfectly illustrate why our Constitution, the shortest in the world, is also the longest lasting. I would also like to introduce our moderator, Stephen Reynolds, and our panelists, Kelsey Holmberg, Jacob Sandstrom, and Jamie Miller. Thank you all.
Thank you, Mr. Newcomb. Ladies and gentlemen, the possession and use of marijuana have been illegal at the federal level since the Marijuana Tax Act of 1937. Many states at first enacted similar laws. Over the past 20 years, however, there have been an increasing number of challenges to the prohibition of marijuana at both the state and federal level. Today, 25 states and Washington, D.C. have legalized marijuana for medicinal use. 4 of those states have legalized marijuana for recreational use as well. In discussing the current controversy over marijuana legalization, this forum addresses a long-standing issue in American jurisprudence: states' rights versus federal power. Please silence your cell phones. Professor Adler and Professor Denning will each have 10 minutes. Following their statements, the 3 student panelists will pose questions. Professor Adler, the floor is yours. Professor Denning, the floor is yours. Start with Professor Denning.
It's only nice to give the out-of-town visitor the first show.
Yeah, the visiting team, as it were, yeah. Professor Adler won the coin toss and decided to defer the second half. Thank you all very much for the kind invitation. It's always wonderful to be here in Cleveland and to participate in anything with my good friend John Adler. I'll make my requisite marijuana joke. I figure we should have started this panel at 4:20, but who's ever on time with those things anyway. What I thought I would do is just set up some of the issues that have arisen as state legalization regimes or liberalization regimes run up against the continued federal prohibition on the production, possession, use, et cetera, of marijuana. And then I think Jonathan is going to pick up and do a deeper dive into some of the issues, and then hopefully you can watch us as our talks both expose the areas of agreement and disagreement among us, and we look forward to hearing the comments and questions. As you know, federalism is a structure of government where you have a national government and then you have subnational units, whether you call them states or Länder or whatever. And federalism issues legally usually have two dimensions. There is the familiar vertical dimension, that is outlining or circumscribing the boundaries between national and subnational power. But then also many people forget about a horizontal federalism dimension, where states often are put into conflict with each other. Think about air pollution or trying to stop the importation of goods like, say, alcohol, which was one of the big issues in the late 19th and early 20th century. Marijuana occupies a position on both of those axes. So I've maybe too cleverly decided to describe marijuana as a diagonal federalism problem insofar as it does partake of these two different issues. And what I wanted to do is just describe briefly the vertical aspects of the marijuana controversy and the horizontal aspects, and then suggest some ways in which marijuana is very much like alcohol and how Congress might intervene to play a constructive role as opposed to the role it's playing now, which is creating a lot of problems. Vertical federalism, as has already been mentioned, the Controlled Substances Act is still the law. It is still on the books. It is still illegal to produce, possess, cultivate, distribute, trade for goods or services, whatever, marijuana. As noted in the introduction, though, nearly half the states now have regimes that either permit its use or permit its production for either medicinal or recreational purposes or both. Now, sort of everybody learns, certainly in law school and probably in your government class, that if you have a conflict between state and federal law trumps, right? So how is it that these states are getting away with this? Well, there are a couple of answers. Number one is found in what's called the Cole Memorandum. The Obama administration finally clarified its position vis-a-vis the states when it issued a memorandum from the Department of Justice, which basically said, states, as long as you keep a lid on things, it's another marijuana joke, as long as you keep a lid on things and you don't become a haven for large-scale drug processing or drug distribution, you don't become a haven for organized crime, you don't let the cartels set up shop in your borders, you keep it away from underage users, and you also don't allow people in the marijuana business to get involved also with guns, we're pretty much going to leave you alone as long as you have some kind of regime in place. Incidentally, the regulatory regime that most states adopt is they want to regulate it like alcohol, even though craft brewers will tell you that our alcohol regulation system is hopelessly obsolete and outdated. I find that ironic. So the Cole Memorandum has created this gray area. In addition, you have to understand that there are limits to what the federal government can make states do. In constitutional law, there's something called the anti-commandeering principle, which says basically that states do not exist as field offices of the federal government. That means two things at least. Number one, it means that Congress can't tell states what kind of legislation to enact. It can't go to Colorado and say, we pass a bill that says you have to recriminalize marijuana. Can't do that. States still possess some aspects of sovereignty that Congress cannot intrude upon, at least directly. Second, Congress can't commandeer state executive branch officials. So even if it couldn't tell the legislature what to do, it also cannot go to state law enforcement and say, we order you to enforce federal law in your state. It can't do that. Now that Congress can create all sorts of incentives, it would make states want to do that, but so far Congress hasn't. The Cole Memorandum exists as sort of the last word on the federal government's position vis-a-vis these state experiments. Now this gray area, however, creates a number of problems. Ask any dispensary owner in the state of Colorado what his biggest expense is, or her biggest expense is, and they'll tell you security, because they are shut out of the banking system for all intents and purposes and have to run an all-cash business. This means spending tremendous amounts of money on security, not only for the cash that's on premises, but also transporting the cash to wherever they're going to put it, because they can't put it in a lot of federally chartered banks. It creates problems in terms of leases. There was a case in which I think there was a civil RICO action filed against a landlord, I think, that had leased space to a dispensary. And the claim was that the landlord was in violation of federal law because they were allowing drug dealing to go on their properties. Finally, just in terms of securing legal advice, the rules of professional responsibility prohibit lawyers from counseling their clients to break the law. Well, a number of states have interpreted this quite strictly. Colorado did for quite a while, and basically said lawyers couldn't do anything for their clients who ran canna businesses. They couldn't do anything that was basically of any use. You could tell people what the consequences are for breaking the law, but you can't say like, okay, well, I'll help you negotiate this lease with your suppliers who are selling you the marijuana that you're going to retail in your dispensary. Now, some of this is slowly changing. Some states where marijuana is legal for medicinal or recreational or both purposes have begun to slowly amend or at least issue advisory opinions that say, okay, look, it's as long as you're complying with state law, we'll allow you to advise your clients on all manner of business. But beyond that, the preemption issues, and the problems that this kind of gray area have created are more difficult to resolve. One argument is that it ought to be that because these state laws impose what's called an obstacle to the achievement of the goal of the Controlled Substances Act, which was basically to end or to shut down the nationwide market in cannabis, that really Colorado's laws and those of Oregon and the other states really ought to just fall off the books. They ought to have no force and effect. But it's hard to enforce that because it's hard to find the right client who could bring that kind of claim in a court or sort of try to force the federal government to act to enforce its laws. Oklahoma and Nebraska tried this and were not successful. Briefly, let me mention the horizontal federalism problems because I'm running out of time. Let's say that you're a state like Colorado who would like not to become a pot tourism destination. Let's say that you wanted to restrict the sale of recreational marijuana to your citizens so you could keep a tighter eye on them and on the traffic. Well, there's something called the Dormant Commerce Clause doctrine, which is a set of judge-made rules that prohibit states from discriminating against or otherwise burdening interstate commerce. That would suggest that Colorado couldn't do that. It would have to become, once it makes the choice to allow recreational marijuana, it can't keep people from other states from coming in and enjoying marijuana. Arguably, they're doing it for good reasons. They're not doing it to create a protectionist market or to depress prices for their own citizens. Rather, they're doing it in order to minimize spillover effects that might harm other states and might draw the heat from the feds. So maybe there ought to be some allowance made for a state like Colorado to keep pot tourism to a minimum if that's what it wishes to do. Finally, I'll just conclude. Maybe we'll get to some of this. I can expand upon it if anybody wants. Probably the easiest fix would be for Congress to allow opt-outs for states from the Controlled Substances Act for those states wishing to pursue a different liberal regime. Now, there's precedent for this. Environmental laws, for example. Other examples with so-called cooperative federalism, the federal government gives states a choice. Either allow us to regulate it, or if you don't want to follow our regulations, come up with a system or come up with a regime that does basically the same thing that the federal regime does. And if we could get Congress to do anything, that would probably be the easiest thing, short of passing a constitutional amendment specifying which branch of government had control over marijuana, like we did with alcohol. Thank you.
Professor Adler, would you like to comment?
Sure. Remarks. Thank you. It's a pleasure to be here. Pleasure to be sharing the podium with my good friend Professor Denning. As my daughter would surely tell you, I'm not cool enough to make marijuana jokes, so if there are any in my remarks, they are surely inadvertent. Professor Denning noted we've had, or actually, yes, our moderator noted that we've had marijuana prohibition since 1937. And I must confess, anytime anyone tells me anything about federal law or constitutional law with a starting date of 1937, I get worried. And so true here. We could talk a lot about what Congress might do or might not do in terms of rationalizing our approach to marijuana and accommodating our federalist system. But it seems to me if we're going to approach that question, we should start at fundamentals and ask why the federal government has the power to purport to do what it's doing in the first place. Our constitutional structure is based on some premises. One of them is that there is no federal police power. There is no general power in the federal government to safeguard health, safety, and morals. That power is left in the hands of our state governments. When our Constitution was founded, the people gave a select amount of power to the federal government, powers that are eliminated and enumerated, written down so that their boundaries shall not be transgressed in the Constitution. And certainly there are powers which could be used to reach marijuana in certain cases, but there is nothing there that I believe can be used to among other things, prohibit the personal use, possession of marijuana or any other substance. And this is something prior to the modern drug war we understood. When our nation decided to prohibit alcohol, Congress didn't pass a statute. The people got together and worked through the Article 5 process to amend the Constitution. It was recognized that to prohibit alcohol in all its uses for moral and other reasons could not be done through a power to regulate commerce among the several states. Rather, it had to be done by granting to the federal government power which the federal government did not previously have. Now, in the 1930s, that view of the Constitution changed somewhat. In cases like NLRB versus Jones and Laughlin Steel, the Supreme Court said the commerce power, when combined with the power to enact all laws necessary and proper to carry into execution the enumerated powers, the court said, well, Congress could certainly do things that regulate things that affect commerce as well. If you're going to try and regulate an industry, perhaps it's not enough to regulate the buying and selling of commodities in interstate markets. Perhaps you have to reach the production of those commodities as well. Perhaps to control interstate markets, you must account for the fact that intrastate markets act as a substitute. Perhaps most famously in Wickard versus Filburn, Farmer Filburn was told that a federal price control statute, a statute that sought to maintain prices for wheat, could be used to prevent him from growing too much wheat on his own property. Wheat that, contrary to popular myth, he was not planning to use to feed his family, but rather to feed his dairy cows, because he was a dairy farmer engaged in production of dairy products for interstate markets. But even this idea that we can tell an individual farmer how much of a given crop he or she can produce so as to control prices in what are admittedly interstate markets is a far cry from saying that a middle-aged woman in California who believes marijuana is helpful for dealing with certain medical conditions that she may have cannot on her own grow marijuana in a backyard or take a gift of marijuana from one of her friends. But yet that's precisely what the Supreme Court declared in the case of Gonzalez versus Raich when it said that the power to regulate commerce among the several states includes with it, or at least that power when combined with the power to do that which is necessary and proper, includes with it the power to say to someone like Diane Ronson or Angel Raich that the intrastate, non-commercial possession of marijuana, even in infinitesimal amounts, can be a federal crime. And that's what the court held in Gonzalez versus Raich, and I'm certainly happy to say, I've said it in print, that this case is hard to square with the text of the Constitution and the understanding of what that text historically has meant. It'd be one thing to say the federal government could regulate the interstate sale and commercial possession of marijuana, one thing to say that intrastate commercial sale and commercial possession is intertwined with that interstate commerce, but quite another to say that this includes the power to prohibit all possession whatsoever, and if one reads the case closely, to even suggest that anything that potentially competes with a commercial product could likewise, possession of that thing could be regulated as well. The federal government may have this power under existing precedent, but since we are celebrating the Constitution, I think it is fair to question whether or not the federal government actually has the power under the Constitution itself. As already been noted, the federal government recognizes that this is something that's hard to do on its own. The Supreme Court may recognize that Congress, or may have concluded that Congress has this power to prohibit marijuana in all its manifestations, all possession and use of marijuana, but the federal government doesn't really have the means to do this. With over 24 states essentially opting out of the drug war in one form or another, either by legalizing medical marijuana, decriminalizing small possession and use, or in the case of a handful of states, fully legalizing marijuana for purposes of state law, the federal government really has a hard time. Consider that in Colorado and Washington, the two states that were the first to legalize marijuana, there are 4 times more police officers in Colorado and Washington than the DEA the Drug Enforcement Agency, has agents worldwide. If state and local governments aren't going to participate in the drug war, it's not going to be prosecuted. And so then the question is, well, what should the federal government do? The 2011 Cole memo has already been mentioned, memorandum from the Justice Department outlining how the Justice Department would not pursue enforcement of the federal prohibition on marijuana in states that had chosen to legalize marijuana, at least so long as there weren't indications that federal priorities had been impacted. There wasn't evidence that possession was being used as a pretext for interstate trafficking, or there wasn't evidence that individuals were involved in distributing marijuana to children and so on. And certainly it would make sense for the federal government to prioritize its resources, but there are constitutional issues here as well. Article 2 of the Constitution obligates the executive branch to faithfully execute federal law. The federal government has an obligation embodied not only just in the president, but those that are responsible to the president, to make a good faith effort to enforce federal laws that are on the books. Well, to say that we won't prosecute in states that have chosen to legalize raises some serious questions there. Now, one possibility the executive branch could have taken would have been to follow the model set by President Abraham Lincoln and to say the court has its opinion of the Constitution, that the court follows in deciding cases or controversies, but the executive branch also has its obligation to interpret the Constitution, and as President Lincoln refused to do with regard to Dred Scott, one could imagine an executive branch saying we are not going to enforce the Controlled Substances Act as applied to the intrastate non-commercial use and possession of marijuana because that exceeds federal power. It would be quite shocking for the executive branch to do so, but I think that would certainly be consistent with the obligation to faithfully execute the laws of the United States. The obligation is not to faithfully follow the Supreme Court's opinion, but to faithfully follow the Constitution and laws enacted pursuant to it. That's not what the administration has done. The administration has not suggested there is any constitutional problem whatsoever with enforcing federal criminal prohibitions on the use and possession of marijuana, no matter how small, no matter how insignificant. It's also not clear that the executive branch has relied upon concerns about resources. I mean, another path the executive branch could have taken is to say, look, we just don't have the resources, and clearly they do not, and therefore set forth priorities for how those resources are to be utilized so as to maximize the benefits from federal law enforcement. And this is something we certainly hope law enforcement does on a regular basis, decide to prioritize resources to focus on those crimes that are most severe. Although if one looks at the 2011 Cole memo, one looks at the subsequent 2013 memo about Colorado and Washington, one doesn't even really see that concern all that present. And so I think it's fair to ask that even if one believes, as I do, that the Controlled Substances Act in these applications is unconstitutional, it's fair to ask whether or not the executive branch is engaged in faithful execution of the laws of the United States as it applied to drugs. This is not just my view. I came across recently a comment written by Harvard Law professor Lawrence Tribe in 1999, which bears on this question, and it's a bit provocative that I thought I would share before closing. He was focused on a different concern at the time, but it is something we're thinking about. In discussing the standards of what constitutes a high crime and misdemeanor for purposes of impeachment, in 1999, Professor Tribe wrote, "Certainly a president who ordered the FDA to stop enforcing the laws against marijuana use because he was philosophically opposed to the regulation of marijuana or because he was widely known to have used it as a youth and feared accusations of hypocrisy would have committed an impeachable high crime or misdemeanor of the most dramatic sort by shredding his obligation to execute the laws of the country." I'm not ready to go as far as Professor Tribe did in that comment, but I think it does suggest that merely because we don't like the idea of the federal government imposing federal law in these jurisdictions does not mean the executive branch has the authority to simply suspend that enforcement due to its policy preferences. Is there an easy way out? Well, yeah, Congress probably could reform a Controlled Substances Act, or we could perhaps have a Supreme Court that's likely to reconsider Gonzalez versus Raich. Unfortunately, I don't think either of those outcomes is particularly likely. Thank you.
Thank you, Professor Adler and Professor Denning. We will now take questions from the student panelists. Professor Adler and Professor Denning, you will each have 5 minutes to respond. Ms. Holmberg, would you like to begin?
Welcome, Professor Denning. The Obama administration has not enforced marijuana laws strictly, but it has taken a strong stance in favor of transgender bathroom usage. What constitutional implications arise from the administration's contradictory approach to these difficult and controversial issues?
Wow. With the softball questions. I think we didn't see these beforehand, as you can tell from the expression on my face. Well, I think it simply goes to the, I think to sort of slipstream along what Jonathan said, I think it simply reflects differences in priorities in what the administration feels is important. I think that the administration has decided that it is going to take a strong stand, both in terms of advancing LGBT rights, and I think that as states, particularly my part of the country, began to react, the administration thought that it needed to extend Title IX or attempt to extend Title IX to cover those situations as well. I would also say that it's probably much easier to vigorously enforce Title IX against some laws which arguably don't do very much and haven't affected very many people one way or the other than to try to enforce the Controlled Substances Act in a situation in which you now have half the states adopting policies at odds with federal policy. And I think that maybe what you could say as I'm sitting up here trying to think of something intelligent, that the administration just knows how to pick its battles.
I think in which I take the unlikely posture of defending the Obama administration. So I think in these sorts of questions, we want to step back from the issue of, well, does this look like a local issue? Does this look like a trivial issue? Does this look like a matter of the sort that we just let local communities solve, and ask and start with the question, what is the basis upon which the federal government is acting? So as I've already outlined, I don't think the federal government has the authority to prohibit the intrastate use and possession of marijuana, or any substance for that matter. I think its authority ends when it goes beyond trying to regulate commerce among the several states. That is what the federal government does with alcohol, and all it could do with alcohol before we had a constitutional amendment. In the case of something like transgender bathrooms, it really depends where we focus. So if we're talking about educational institutions, the basis for federal action there is something called Title IX, which Professor Denning mentioned, which is, among other things, imposes conditions on all recipients of federal funds. And again, going back to 1937, which is as I've already noted, a bad place to start for constitutional law doctrine, it has been accepted that the federal government can place conditions on the receipt of federal money, and a long-standing condition on the receipt of federal educational money going back to, I guess it's 1975. Well, 75 for the gender part, or the sex part? In any event, the Title IX was enacted in 72 and then amended in 75, prohibits discrimination in the provision of educational facilities on the basis of sex, but does contemplate the provision of single-sex facilities. And the administration has taken the position. There are administrative law questions about the way they've gone about this, but as a constitutional matter, they've taken the position that all they are doing is enforcing this condition. And that raises legal questions. I don't think it raises constitutional questions. They're saying if you receive our money, you can't discriminate in the way you provide facilities. The other point I would just note is that we have enshrined in our Constitution the idea that equal treatment, and that's a phrase that has to be unpacked. We have to figure out precisely how it applies in different circumstances, but that principle at some level is something that is imposed on the states. That was part of the many years of constitutional reformation that occurred after the Civil War. And insofar as one characterizes what the Obama administration is doing as at least aspiring towards fulfilling that principle, it's actually doing something that is in line with our modern conception of what the federal government should be doing, saying to other levels of government, whatever you do, be sure you aspire towards this principle of equal treatment. I don't think there's anything remotely approaching that one can posit in the context of something like the drug war or marijuana. So I think that when we kind of approach it from that standpoint, we can suggest that the constitutional starting place is different in these two contexts. From what we think about this as a policy matter, separate question, but as a constitutional matter, I think we have two different starting points.
Thank you. Mr. Sandstrom?
Yes, thank you. Professor Adler, we welcome you again. As you know, a state generally may not pursue policies that violate federal law. In 2005, the Supreme Court ruled in Gonzales v. Raich that the use of marijuana for any purpose is illegal, striking down California's medical marijuana policy. Just last month, the Drug Enforcement Agency reasserted that marijuana is a Schedule I drug, the same classification given to heroin. Nonetheless, 25 states, as we've mentioned, including Ohio, have legalized marijuana for medicinal use, seemingly in violation of federal law. Since federal law supersedes state law, how can a state justify legalizing the use of marijuana?
So this is an issue that comes up a lot. We've seen it come up in the context of immigration. We've seen it come up in the context of national security policy. States have no obligation to do anything to enforce, facilitate, or operationalize federal law. That the Supreme Court has made that clear in a handful of opinions, New York versus United States and Prince. It's actually a principle that goes back earlier than that. There are even cases from the 1970s where the Supreme Court didn't have to reach that decision because the Solicitor General's office refused to argue otherwise. There are even cases that go back to the 19th century that assert this idea that where the federal government has a power, the federal government must do it. It shouldn't be done simply by states, or states can't be forced to do it. They may voluntarily choose to. So the preemption issue isn't can a state like Colorado or Washington or Ohio simply say, we're done, we're walking away, feds, you go enforce it. Because there's not really a constitutional question here. This is the same thing that local communities do when they adopt sanctuary cities for purposes of immigration law. All they are simply saying is, feds, if you don't want there to be lots of immigrants in our jurisdiction, you can come and round them up. We're just going to sit back and do our own thing. Perfectly constitutional for a state or local government to do that. Where the preemption question gets trickier is where a state, as Ohio has, as Colorado has, as pretty much all the medical marijuana states have, and where the states that legalized have, go beyond that and say, not only are we going to say that something is no longer criminal, we are actually going to create a state apparatus that will regulate it, that will license it, that will systematize it, standardize it. The Constitution, I think a serious preemption question emerges because the state is no longer standing back and saying, feds, this is your game, you do it. They're actually saying, we disagree with you and we're going to set up a different set of rules. I think there is a serious question about whether or not, if the federal government sought in court to have those regimes preempted, whether or not the federal government could see those preempted. And one reason I think it's a serious question is we do have recent cases where courts have said that when states seek to enforce a federal law more aggressively than the federal government, that can be preempted too. That happened in a recent immigration case. So I think that's a serious preemption question. One other little wrinkle is a couple of states, Nebraska, Oklahoma, I forget who else, but Nebraska and Oklahoma tried to raise this argument, brought a bill in the Supreme Court under its original jurisdiction, asking the Supreme Court to declare that Colorado's law is preempted. And again, I think their preemption argument was not frivolous. But I think one reason why the court didn't hear the case is because the remedy they were effectively asking for, or the only remedy they could ask for, would be for Colorado to abandon its licensing regime. And if Nebraska is seriously complaining that Colorado's legalization of marijuana results in there being more marijuana in Nebraska, because people go to Colorado and buy it, bring it back, it's hard to argue that having marijuana be completely unregulated in Colorado is somehow less a threat to Nebraska than it being heavily regulated in Colorado. And so the effort to claim preemption there seems a bit incongruous because they were essentially asking for a judicial remedy that would have made things worse for them, not better. But the underlying idea that if something is prohibited under federal law, that a state regime, not simply legalizing, but regulating, licensing, and so on, could be preempted, I think is a serious question. And as Professor Denning already hinted at, for lawyers, it actually raises serious professional responsibility issues because as members of the bar, we are not allowed to counsel our clients to engage in prospective violation of the law, and that includes federal law. So, for example, and I'll just finish up with this, if I am an attorney in Colorado and my client wants to create a cannabis club, and I help that client with the LLC papers or the papers of incorporation and so on, as our code of legal ethics have traditionally been interpreted, it's not clear how I'm not violating my oath and engaged in conduct that could result in my disbarment. And I think that's a serious issue too that I think states like Colorado have tried to evade, but I'm not sure that whether they've really done so on a principled basis.
Let me elaborate on something that Jonathan mentioned about the remedy. I think the preemption issue is very tricky, and it's much trickier than I appreciated, I think, at the time. And let me be clear. Preemption can take many forms. Congress can pass a law that explicitly preempts state law. That's not the case in the Controlled Substances Act. Congress didn't say states may not pass laws that are inconsistent with this law. However, the Supreme Court has developed a whole body of so-called implied preemption, one of which is called obstacle preemption. And states, even when states attempt to create parallel regulatory regimes that track closely the federal government's, but maybe have one or two aspects that are strict or more strict. Jonathan mentioned Arizona's immigration law. Arizona tried to craft it so it looked very much like and actually used many of the terms and adopted the structure of federal law. And the court nevertheless said, look, you made choices that Congress considered and rejected. Your law, though it parallels the federal regime, stands as an obstacle to the accomplishment of congressional aims. And I think that the same argument could be deployed to say, look, I mean, the very fact that Congress has tried to eliminate the market that you were attempting to establish and regulate, I mean, attempting to establish and regulate a market that Congress wanted to, I can't think of a more obvious obstacle to the accomplishment of congressional goals. That leaves the question of finding a party that could bring, that had quote unquote standing, that is, that was the proper party to bring the suit. And as Jonathan mentions, what kind of a remedy? Now, I happen to think that this choice between regulated and not regulated is a false one. Because if a court were to say to Colorado, look, you have to dismantle your entire regulatory regime, I do not think that what you would have is sort of this marijuana Wild West in Colorado. I think the legislators of Colorado would probably recriminalize. Or if they didn't, and you did get a regulated, this unregulated Wild West market with, marijuana saloons on every corner or whatever, I think the feds would step in very quickly and begin to make it a priority of enforcing laws within that jurisdiction. So, the regulated, the remedy is a tricky question, but I don't think it's insurmountable. Possibly the trickier question is whether just by bringing suit against the state of Colorado, you've involved all the parties who are responsible for the injury that Nebraska and Oklahoma are claiming, because it isn't as if Colorado is running state-owned marijuana dispensaries. It isn't as if the state, like some states do with liquor, Virginia, for example, it's not as if they have created a liquor monopoly or a marijuana monopoly and it's just the state. You've got a whole bunch of private parties that are involved. And so I think that also complicates the issue and makes it fun for, particularly constitutional law professors who like structural questions. It makes it fun for us. Let me mention, though, one consequence of the continued federal prohibition. if you use an illegal drug under federal law, you are prohibited from owning a firearm. It says addict or user. So if you are a regular visitor of a Colorado dispensary, Colorado has inadvertently made probably thousands of its residents and thousands of visitors federal criminals. And let me tell you something, if there's one thing that the feds are interested in punishing, and punishing strictly, it's gun crime. You get caught violating federal gun laws, and you are going to do time, and that time is federal, which means there's no parole. So, there are all sorts of knock-on effects from the continued federal prohibition coming into contact with these more liberal state regimes, and it's the banking issue, lawyers, gun owners. I mean, lots and lots of people are impacted, and inadvertently have been made to be probably federal criminals, even if they haven't been prosecuted. Thank you.
Well, thank you. Ms. Miller?
Thank you. Hello, Professor Denning. Hello. Nebraska and Oklahoma assert illicit marijuana usage has increased ever since their neighboring state, Colorado, legalized recreational marijuana usage. In your view, what legal grounds do Nebraska and Oklahoma have to win a lawsuit against Colorado?
Ooh, I know this one. States can bring suit against other states, and states can assert special interests by virtue of their being sovereigns. So they can assert interests on behalf of their citizens that are unique to the state. And this is, I mean, it's very technical, and I won't bore you too much, but it's called parens patriae standing. So states could go in, and what Nebraska and Oklahoma did, which was kind of neat, is suits between states can be brought directly to the Supreme Court as part of its original jurisdiction. That is to say that they would initiate the suit in the Supreme Court as opposed to filing suit in a federal district court and then appealing it up. And that's precisely what they tried to do. Now, the Supreme Court has enormous jurisdiction whether or not to hear these cases. If they do accept it, usually what they do is they fob them off on a special master who compiles a bunch of facts and then gives it to the justices, and then they vote and write an opinion. Here, my strong suspicion is that, one of the catches on parens patriae standing is that you can't simply bring it on behalf of a group of citizens or assert interests that are the same that other citizens would have. In other words, let's say that what let's say what Nebraska and Oklahoma were complaining about was that Colorado pot was undercutting the price of their own pot producers' product or something, right? I mean, that's not exactly the kind of sovereign interest that states would be allowed to assert in court. The usual parens patriae standing case, there are a couple of very old ones that involve pollution. One state's pollution is affecting affecting the natural resources of another state, and the state can step in and say, look, and it may be that a private party would have to accept damages for that kind of injury. And the Supreme Court has said, well, since it's a state and they have special interests, they could, for example, get an injunction where a private party could not, because they're special in the sense that they're standing up for the special interests of all their citizens. And that's certainly what Nebraska and Oklahoma tried to do. And as Jonathan mentioned, there were problems about establishing some of the different prongs of standing. Then real questions about, well, sort of what next? Now, I mean, there are differences that we have on what might have been a possible remedy, or if any remedy actually existed. But that would be essentially they were asserting that, look, there are dramatic spillover effects that are occurring because of what Colorado is doing. They're violating federal law. We think that someone ought to compel. We think that the court or the executive branch or somebody ought to be enforcing federal law to stop these externalities or these spillover effects that are having a detrimental effect on our population. Now, the response from Colorado was like, look, first of all, you can't necessarily prove that all came from us. Second of all, you want to enforce your laws, it's up to you. You're choosing to enforce them more vigorously in response to our legalization, and that's just a choice that you made. It's not on us. And, sorting out all those arguments, who knows how they would have played out in court. The court, though, didn't seem very anxious to engage any of the questions, and so therefore just decided, it wasn't going to hear the case. But it certainly would have been interesting to see what they would have done, whether they would have bounced it on standing, saying that there were insufficiently unique interests that the state was asserting, or whether they would have blown past that and got to the merits and had something to say about the obligation of the federal government to enforce laws against sort of contrary or more liberal state regimes.
I think the analog to the old common law pollution cases as interstate nuisances is interesting. So, as Professor Denning mentioned, you had a long history in the United States of if there was pollution generated in one state that crossed state lines, the downwind or downstream state would take action on behalf of its citizens or on behalf of the state as a whole. One of the more famous cases, a case called Georgia versus Tennessee Copper. But note, that case is not Georgia versus Tennessee. It's Georgia versus Tennessee Copper. That is to say, Georgia was seeking to defend itself as against a particular facility that was spewing pollution that was harming the natural resources and the interests of citizens of Georgia, not claiming that another sovereign jurisdiction had this obligation to take some affirmative action. So I think that Nebraska, let's say there was a marijuana dispensary on the Colorado-Nebraska border, and Nebraska believed a lot of Colorado was being sold there to Nebraskans that were then taking it over the border. Perhaps there might be an argument that a claim could be made against that facility and claim that where Nebraska could get an injunction and not merely money damages. It seems to me that that sort of case would have been a better parallel than what Nebraska and Oklahoma tried to do. But even if they were going to use that sort of fact pattern to identify the problem that they were complaining of, it's really not clear what they could ask for other than some greater effort to be made by Colorado to prevent the illegal export of marijuana to prohibitionist jurisdictions. What they were actually asking for, I think, really went too far. I think the bigger point, though, is that we have to keep in mind is that states in our system have no obligation to facilitate the preferences of other states. The very idea is that different states will have different preferences, sometimes radically so. And that it might not even be just a question of preferences. We might think that the policies of other states are profoundly morally derelict. We might think that they are odd, they are strange, they are perverse, and yet our system says, well, if it's not squarely in an enumerated power of the federal government, too bad. We don't generally say that because some products are legal in one state but not legal in another, that the prohibitionist state gets to impose any obligation whatsoever on the state where something is legal. And this is true with radar detectors, which are purchased in some states to help you violate the law in other states. Why wouldn't this be true of marijuana as well? Now, one other comment I just wanted to note on this question. I'm actually quite skeptical that there are these dramatic spillovers. I'm skeptical about the causation that Nebraska and Oklahoma are asserting. And I'm reminded back in the case of Gonzalez versus Raich, it was really interesting. There were two amicus briefs filed in that litigation on behalf of states. Interestingly enough, both of them on the side of Diane Ronson and Angel Raich, on the side of the individuals that did not think that their possession and use of marijuana should be criminalized. One of these briefs was written by states that had allowed medical marijuana, states like California and so on. Well, of course, you'd expect them to support the individuals that wanted to be able to use and possess marijuana for medical purposes. But there was another brief filed by Mississippi, Louisiana, and Alabama, in fact, written by the Solicitor General's Office of Alabama. And these were not states in which medical marijuana was allowed. In fact, these were states in which the penalties for the possession of even small levels of marijuana were by far the most serious and stringent in the nation. And if you go read their brief, and I'm going to paraphrase it, it basically said, if you come to one of our states with a little bit of marijuana in your pocket, we have no problem knowing what to do with you, and you'll be put away for a very, very long time. But those hippies in California have different preferences, doesn't create a problem for us. When those folks cross our border, we can deal with them. That's the structure of the system. That's the way it's supposed to work. And I suspect that Nebraska and Oklahoma were filing this suit for political purposes, and not because there is any real evidence that they're being done harm by the fact that people in other states have made different policy choices.
We have time for one more question from the student panel. Ms. Holmberg, would you like to ask the final question?
Professor Adler, why do you think the administration has opted for non-enforcement of marijuana laws, as some say? In your view, has the Obama administration's lack of enforcement of these laws been constitutional?
Short answer, because they don't have any other good options, and then no, probably not constitutional. So on the why they don't have very many other good options, as I've already mentioned, I mean, the federal enforcement of things like the drug war is dependent upon, like lots of federal crimes, is dependent upon having the active participation of state and local governments and state and local police forces to essentially serve on the front lines. And federal law enforcement is often brought in because they have greater resources, because they can deal with certain types of complex crimes, and because in certain cases the penalties for violating federal crimes are so much more, so that when you find the person you really want to put away for a long time, you let the feds prosecute that instead of the states. So the feds need the states, and if certain states aren't going to cooperate, the feds have a hard time doing that. I think the problem, and why I at least have questions about the constitutionality of it, is because I do think there is an obligation to faithfully execute the laws. And I think there are really only two grounds upon which the executive branch can make a judgment that a portion of federal law will generally not be enforced. One is a sincere and good faith belief by the executive branch that enforcement of that law would be unconstitutional. So, for example, to use another recent example, President determines that enforcing the Defense of Marriage Act was unconstitutional. The proper course would be to say that that would no longer be enforced by the federal government. And for those that are interested in this question, Judge William Pryor, who's also from Alabama, gave a talk here a couple years ago, which was published in the Case Western Reserve Law Review and should be available on their website, that talks about the very real or the important idea that executive branch officials actually have an obligation not to enforce laws that they believe are unconstitutional. But the administration clearly doesn't believe that this law is unconstitutional, clearly believes that the expansive notion of the commerce power embodied in the Controlled Substances Act is just fine, and it's not alone in that. There has not been a presidential administration to take a contrary view in some time. I think had they actually then decided, the other option would have been to essentially engage in triage and really identify the resource constraints and base decisions on that basis. And it's not clear that it really has done that either. It's basically said, well, as a general matter, we'll kind of prioritize this stuff, and if you do these things, we probably won't give you a hard time, but we might change our minds. And I think that that's not particularly helpful. I mean, it's a way of saying that it's like the cop on the highway saying, well, if you're only going 8 miles over the speed limit, most days I probably won't pull you over, but you never know. I mean, not very helpful, right? I think that what the administration should have done is either gone to Congress to seek more resources, or gone to Congress and seek more explicit guidance. Congress is interested in at least providing a little bit of guidance. There's an appropriations rider that's passed the last several years that bars the federal government from spending money to inhibit the implementation of state laws legalizing marijuana. So it seems to me there's an opportunity. The administration could have worked with the Congress to develop a more finely tuned appropriations rider, or even a substantive reform that would have created more space. Another option it could have taken under the Controlled Substances Act is there's a provision that allows the federal government and state governments to enter into cooperative agreements to redefine enforcement priorities in a given jurisdiction. They haven't done that either. So I think they did have some other options. And it's unfortunate that they did not pursue them, because basically now there is a memo that can be repealed at any time that is opaque enough that it really allows the administration to do what it wants when it wants to do. That's, I don't think, the proper way to deal with this sort of question.
I don't really have much to add, although I do think it's worth contemplating, that we've seen a lot of movement on this issue, certainly in my lifetime, that I never expected to see. And I think the administration is sort of, was sort of caught maybe, as a number of people were, I think, with the speed by which public opinion was shifting on marijuana, and was caught sort of in a hard place. I mean, it's because before the Cole Memorandum, for example, the DEA had executed some raids on dispensaries in Oregon and had shut a number of them down. And so people were really confused about what the administration's position was. And I think that probably at the time it was trying to figure out how to handle the shift in the states, how to handle the shift in public opinion and everything else was going on. I think the Cole Memorandum probably represented the least, probably sort of the minimum response to the issue that the federal government could adopt without having to go to Congress. And of course, for whatever reason that you want to subscribe to, the executive branch, at least the last several years, has not been interested in engaging very seriously with Congress to try to effect change in law. Instead, trying to press executive power as far as it can go and take those steps that it can unilaterally, at least until a court says you can't do that. And that's certainly been the pattern, particularly on highly salient and divisive issues like immigration, and I think on Title IX, in both not only in the transgender bathroom issue, but also on campus sexual assault. I mean, these are the administration has moved very aggressively under some fairly strained interpretations of the existing law, and I think this is maybe sort of a piece of that. And the DEA's reaffirmation of marijuana as a Schedule I drug is just another example of sort of that tension within the administration about. And if I were a dispensary owner, I would be very, very nervous. I mean, the Cole Memorandum is worth the paper that it's written on. And again, could be, President Clinton could come in and just say, it didn't do Bill any good, so inhale or not, so I'm going to get rid of all this and leave a bunch of people with stranded costs and exposure to prosecution. Another thing that I'll mention again, the DEA, or sorry, the Bureau of Alcohol, Tobacco, and Firearms issued a directive to all federally licensed firearms dealers saying that anyone who's holding a medical marijuana user card is ineligible to purchase a firearm. And so again, I mean, you see that this gray area that's been created here, this clash between the federal government and the federal prohibitionary regime and the more liberal state regimes, are putting people at risk for prosecution, on things that are really ancillary to sort of the main issue about whether marijuana ought to be legal or not. And certainly it's a great big mess, not the least of which to people who are trying to run a business under or solicit legal advice to know whether they're complying with the law or not. And I think overall it's probably an example of how not to reinforce or strengthen rule of law as a general proposition.
Thank you.
The speakers will now entertain questions from the audience. Please keep your questions short and concise.
Okay, so I have both a quick comment. So I have both a quick comment and a question. The quick comment is we tend to talk about the federal government, and it's not at all clear to me that the various agencies of the federal government actually coordinate with each other fully on such matters. So I would be surprised if the DEA decision about classification necessarily rose to the presidential level, for example. Who knows? But if I'm the president, I don't want to touch it. So maybe I don't want it to rise to my level. The question is just a simple one for Professor Adler. What is in this appropriation rider? Because by the language that you have used, the appropriation rider seems to justify what the government is doing in the Cole memo.
What's in the appropriations right is a good question. There's been some litigation about it. The language says that money cannot be used to I'm paraphrasing, interfere in the implementation. Federal government's the executive branch's position on what this means has been that that means they can't put state officials in jail or seek to have the laws preempted in a federal court action, but does not in any way inhibit their ability to prosecute individuals who are acting consistent with state law, but violating federal law. In federal court, there have been some individuals who have sought to defend themselves against prosecution, saying, "Oh no, you can't even seek a federal prosecution against me if I'm acting fully consistently with state law. You have to allege some violation of state law because that would somehow untangle or contradict what the state law is trying to do." And some courts seem to have been somewhat, there's at least one decision where a lower court was somewhat sympathetic to that position. I don't think that's actually a fair reading. I mean, I think that if one just reads the language of the appropriations rider, I think that the position of the DEA and the Justice Department is more consistent with the actual language. Because to obstruct the implementation is different from to prosecute activity which is legal under state law. There are all sorts of things that are legal under state law the federal government may prosecute. And the rider is clearly not meant to prohibit, for example, the federal government seeking higher penalties for possession levels that are generate one penalty under federal law, but a different penalty under state law. That's clearly not what it's about. What I would hope would happen is that the authors of this appropriations rider would make it more explicit and perhaps even more expansive, because then I think it would both give the executive branch more guidance for something like the Cole Memorandum. It also would perhaps justify a more concrete policy than this kind of, well, we're kind of not going to enforce unless one of these things is present, and we're not going to tell you when they are. The last thing is that there are other areas outside of criminal enforcement at the Department of Justice where this actually would matter. So, for example, in the banking sector, when we did a symposium on this question a couple of years ago with the law review, another Alabama connection, Julie Hill, who's a professor at the University of Alabama, reported that at least at the time, and I believe it's still the case, that there's not a single dispensary in Colorado that can take credit cards. And the reason is because the banks that actually do the credit card processing can't knowingly process the payment if they know it's on a dispensary. So the initial response was, well, we won't take credit cards, we'll just set up ATMs and put them in our vestibule or put them right in front. Well, under the way the bank compliance people interpret the various anti-money laundering and so on laws, can't do that either. So when she did her paper, all but one of the ATMs within, 10 yards or 20 yards of a dispensary had all been shut down as well and rendered inoperable. A more explicit rider would also perhaps help the federal government deal with this. I think the administration in the banking context, there was another memorandum specifically on that, tried to give the banking sector more certainty. The problem is that the way federal law is written and the way the regulations are, unless Congress gives them more tools to work with, they really couldn't offer the banking sector any certainty or any relief, and so we have that status quo. So my view is that since Congress seems to have this interest in prioritizing enforcement dollars this way, and the administration, I think, is trying to do something in this area, that they should be able to figure out how to either develop a substantive provision or an appropriations rider that more concretely achieves these goals than what either has done thus far.
Right behind you.
Hi, thank you. We've been talking a lot about what the Supreme Court has said about the Constitution and about whether the executive branch should be going to court to enforce the existing federal laws, but let me try to switch the focus slightly. Half the states, as both of you have indicated, have adopted policies that are at a minimum in serious tension with federal law. And so I want to ask, how should we, the people, think about the meaning of the Constitution when the states so many of the states have adopted policies that are in tension with federal law? And to what extent might we think about what the states have been doing as representing a device for trying to get Congress to change federal law, irrespective of what the Supreme Court has said the Constitution might mean?
Wow, that's a great question. So, so I guess that really gets at the heart of who liquidates the meaning of the Constitution. We've all sort of, certainly within the last 50 to 60 years, kind of accepted without question the notion that the Supreme Court is the authoritative interpreter of the Constitution and prescribes meaning that binds all other governmental actors. That hasn't always been the accepted view. Although when it was questioned by Edwin Meese in the 80s, people lost their minds because, of course, that view of the Supreme Court as the final and authoritative interpreter of the Constitution basically kind of solidified at a time in which states were opposing federal policy and opposing policies for bad reasons, right? In Cooper v. Aaron, the Supreme Court declared that, told Orville Faubus, the governor of Arkansas, that despite the fact that Arkansas was not a party to the Brown litigation, that he had to follow Brown versus Board of Education and had no choice, and claimed that that's what Marbury v. Madison held. Of course, Marbury v. Madison held nothing of the sort. Now, I think, as we get farther and farther away from the sort of second Reconstruction and the battle over segregation, I think we've developed a lot more space to talk about, well, who determines the meaning? And I think certainly what you're seeing, and I think this is where you're going, that we the people do have a role in declaring what the Constitution means. And in many cases, the Supreme Court will be a lagging, not a leading indicator of what it will simply ratify what is an expected, what people have come to expect the Constitution to mean. And I'll give you an example. Going way back to the mid-1990s, 75% of people polled believed that the Second Amendment guaranteed an individual right to possess a handgun. 75%, overwhelming majority. I mean, every time they would poll. And this is, 20 years before the Heller decision. And only in 2008 did the Supreme Court catch up and say, yeah, the Second Amendment guarantees an individual right to possess a handgun for self-defense. And so I think that, and in the intervening 20 years, what had happened was that view began to be propagated and began to circulate. Gay marriage is another one. As public opinion began to shift on the gay marriage issue, 2003 in Lawrence v. Texas, the Supreme Court ornaments its decision in Lawrence, which struck down Texas's homosexual sodomy statute, criminalizing homosexual sodomy, ornaments it with all sorts of signals that we're not saying a thing about marriage, not saying a thing about marriage. Lower courts took the cue. 13 years later, public opinion had shifted. It had gone from majority opposed to majority approved. And, mirabile dictu, the Supreme Court suddenly found that indeed, that the 14th Amendment did guarantee the right of same-sex marriage, just as it had guaranteed the right of interracial marriage back in the late 60s. The issue had never come up. So, I think what you're seeing, and I'm being a little facetious, that we the people do have an impact on what the Constitution means. And certainly the Supreme Court, in many ways, is a mirror, not a lamp, a mirror reflecting expectations about what public opinion means. And which is also to say, the flip side of that is if the Supreme Court gets too far out of line with public opinion, I think you'll find very quickly that the Supreme Court will find that its writ doesn't run very far. And this is a point that's not new to me, although it sounds, you can attribute it to me if you'd like, but there's a man named Alexander Bickel, who was one of the most brilliant scholars of his generation, wrote a book called The Least Dangerous Branch, which is, it's Mark Twain's definition of a classic. Everybody talks about it, and very few people have read it. And the important part of the book, Bickel talks about Brown versus Board of Education. He said the Supreme Court's only role, or one of the Supreme Court's role, is to anticipate emerging consensus. And if it gets it right, then then yay, it partly did its job. But if it gets it very wrong, and if even a minority of people began to oppose and actively work against the holding of the court, and begins to convince enough people that the court was wrong-headed, then it will find that its decisions won't have any staying power. And he said that the Southern Manifesto, which questioned the constitutional basis for Brown, began to work. And then Southerners took to the streets and started beating people up. And he said then, that's when they sort of lost their audience.
I agree with a lot of that. I'm going to take a slightly different tack and to raise some warning flags. It's we the people, not we the states. Right? That was deliberate choice. The Articles of Confederation had been essentially a treaty among sovereigns. The Constitution was expressly sent to ratification conventions, not to state legislatures, because it would represent the people and derive its power from the people, not from the states. And federalism is about protecting the people, not about protecting the states as states. And the court hasn't always recognized that, or political dialogue hasn't always recognized that. And so while I like the fact that a majority of states are challenging the federal government on marijuana, but I think we should all be really nervous with the idea that if a majority of states opposes the federal government's understanding of a constitutional principle, opposes a particular interpretation of constitutional text, or opposes a certain federal policy, that necessarily controls the outcome. And we can just think of some examples. In the Affordable Care Act litigation, a clear majority of states had sued the federal government declaring that or claiming that the Affordable Care Act was unconstitutional. A majority of states have adopted or attempted to adopt abortion restrictions, which the Supreme Court would declare unconstitutional. A majority of states are currently in federal court right now arguing that the Clean Power Plan to control carbon dioxide emissions from the EPA is unlawful. And we can go on. And if I go on long enough, I'm sure if I haven't identified one that makes you nervous, I could find one that would. And so, states sometimes are places where we can see or for dialogue and discussion and for the emergence of concerns about policy and laboratories of democracy and places where we can try out new policy positions or new ideas about what the nature of our social compact should be. But states also have their own interests. State policymakers in particular often have interests that are not in line with people as a whole. And I would, even when it lines up with my policy or even constitutional preferences, I'd be wary about suggesting that a head count of states should really do too much work in determining what our constitutional principles should be.
Yeah, so how do you see this playing out? Is it is the federal prescribed substance act going to be removed, and is that the solution, or what? How do you see it playing out?
If I knew the answer to that, I'd have to charge you a lot to give you an accurate prediction. So instead, I'll just give you a unfounded speculation that's worth what you've paid for it. I think that there are a couple interesting factors to think about. One is the Democratic Party has recognized that this issue can drive turnout at the state level better than a lot of other issues. That is probably one reason why the Republican legislature in Ohio was happy to allow a medical marijuana bill to go through, so as to prevent there from having been a ballot initiative this fall, because Republicans weren't sure that they wanted large millennial turnout in a presidential election year. And there's pretty good data on this, and that's so there are political things which will affect what happens at the state level. The law enforcement community, though, generally is very resistant to anything which takes away a tool, right? The ATF likes you can't have a gun if you even have a marijuana card, because that increases the number of people that they can prosecute. Of course, they would tell you they're only going to prosecute the really bad guys, but just as we got Al Capone for tax evasion, we may have to get some drunk kingpin on some ticky-tacky gun possession crime or something. And that makes it hard to enact any type of criminal justice reform at the federal level, including something like this. My hope is that either Congress at some point is more aggressive. If one looks at the Republicans that have been supporting limitations on spending of federal money on the drug war, you do have folks like Dave Joyce here in Ohio, some Republicans in California that are generally known as quite conservative on every other issue, which suggests there might be a possibility of building broader coalitions there. It's also possible that maybe people look for a kind of a sneaky way out, like Congress forcing some kind of reexamination of the scheduling of marijuana, which is a bit, the idea that, what everyone thinks of marijuana, the idea that marijuana is equivalent to heroin is just kind of hard to take with a straight face. So perhaps, you know, you might see politicians that are afraid to actually stand up and take a bolder position, do something to encourage the federal government to take a position that would at least create broader openings for state level reform. Last thing I'll just say on that is that generally, if one looks at Colorado in particular, a lot of the horror stories that some predicted haven't come true. Is marijuana use up? Yeah, sure. It's actually down in certain youth categories. Driving under the impaired driving is down in Colorado. I mean, a lot of things that people were, you know, practical things that people were worried about don't seem to be quite manifesting themselves. And so it may be like a lot of other things that once it becomes demystified, public opinion may change enough that politicians are happy to jump in front of the parade that's already formed.
A couple things on the impaired driving and the one place, if I were going to try to start, one place might be to adjust federal law to loosen restrictions on research. I mean, there's a lot of anecdata around about whether marijuana is harmful, not harmful. You know, I'm agnostic, but I certainly don't believe, I think the legalization folks are doing themselves a tremendous disservice and setting themselves up when they say that it's less dangerous than alcohol or not dangerous at all or whatever. I mean, we just don't know. And I think that a good place to start would be to try to do some research. Right now, it's almost impossible. Like there's one place you can grow it, I think, for research purposes. It's on the campus of Ole Miss. Thank you, probably Senator Stennis, I suppose, you know. And so I think, and also, I mean, about the impaired driving, we just don't know because there's no reliable test for impaired driving or impairedness when it comes to THC. Also, I mean, to the extent that we already have one intoxicant, alcohol, that causes all sorts of, you know, social problems, there's also a question about, well, I mean, it doesn't necessarily follow that you go on ahead and legalize another intoxicant that has unknown problems, perhaps. I mean, you know, and that's not, I'm not, you know, anti-marijuana. I'm just saying that I think that it does present a series of questions, and states, I think, are sort of rushing in with their eyes on revenue without considering public health consequences necessarily. So I would hope that would be a place to start, but since it's sort of logical, I suspect that's not how it's going to go. I suspect that the next real, I think the action is going to be in the Northeast. I think there are a number of states in the Northeast that are beginning to consider it. It's on the ballot, I think, in a couple of places. And I think you'll see a sort of domino effect that once a couple of states in the Northeast become, you know, legalize it for recreational purposes in particular, I think that you'll see a bunch of other larger states follow suit, if for no other reason than to keep from losing revenue. And then I think you'll have, you know, you might see one of these big population swings in which Congress just simply doesn't have any choice but to get in and either allow states to opt out or rethink the scheduling or some sort of halfway measure that preserves the option of cracking down if things go badly. But I think I think we're very close to a tipping point, actually, sort of societally, and I think Congress is way behind in terms of catching up with where public opinion is.
Thank you. I was prompted to ask this question by something that Professor Adler said, but either of our speakers could certainly answer it. Professor Adler mentioned that regulating a substance such as alcohol or marijuana could not be done under the Commerce Clause but required a constitutional amendment, as was the case with alcohol prohibition. I'm wondering what you think that would imply for federal laws meant to reduce pollution, such as the Clean Air and Clean Water Acts.
I don't think it has a big effect on the Clean Air Act or Clean Water Act for a bunch of reasons. One is insofar as you're regulating products that can be sold. I think that's still consistent with the commerce power. So you could still impose standards on cars that are sold. You could even say cars in interstate markets, which would still be pretty much all of them. You could limit if we limit our regulations to industrial facilities, you're still replicating what the Clean Air Act does. For those that are interested, I have an extensive piece in the Iowa Law Review from, 9 years ago, 10 years ago, that goes into detail and identifies what parts of federal environmental law are threatened by a more faithful interpretation of the Commerce Clause and Necessary and Proper Clause. There are some areas where federal environmental law would have to be rethought. They generally involve efforts to control land use, particularly where that land use is not necessarily or not inherently tied to commercial activities. So federal wetlands regulations would have to be rethought. Certain applications of the Endangered Species Act would have to be rethought. And there's actually litigation pending in the 10th Circuit in a case called it's Fish and Wildlife Service versus People for the Ethical Treatment of Property Owners is the name of the case. But that involves a constitutional challenge to regulations that are designed to protect the Utah prairie dog, which is a threatened species under the Endangered Species Act. I think there are serious constitutional issues there, and also written about how there are other enumerated powers that would enable the federal government to achieve the goals we have under those statutes, but those are typically not pollution control, which I think is relatively easy under a relatively limited conception of federal power. Other types of conservation measures require the use of a spending power, the ability or the power of the federal government to hold and create rules for the management of its own property, such as federal parks and forests and so on. And so I think there would be some shifts there, but it wouldn't necessarily affect pollution control laws if we were to adopt that kind of understanding of the commerce power.
Yeah, I would add that going back to I guess it was Gibbons v. Ogden, which is an 1824 case. John Marshall talked about the scope of the commerce power, and he said that it included commerce that affected more states than one, as opposed to the completely internal commerce of the state. And so I think that there's this kind of notion that if you are supportive of limitations on Congress's power to regulate interstate commerce, such that it can't just simply violate what a friend of mine calls the non-infinity principle, which is basically if you have an interpretation of the Constitution that its defenders will admit has no limitation, then it's probably the wrong interpretation, because enumeration is supposed to mean something isn't enumerated, right? It's to cover something, not everything. Otherwise, you would just have the Commerce Clause, and that would be it. Article 1 would be one clause long. So it doesn't necessarily mean that if you support the idea of enumerated powers that you want to take us back to, kind of this antediluvian stage where there's, some kind of Robert Nozick, anarchic state. It just means that there's some things that have to be done either through other powers, and there are 17 of them, plus the necessary and proper clause, or have to be done in cooperation with states, which is certainly what the federal government did before, courts began to violate the non-infinity principle. And environmental laws are one of those areas in which, in particular, where it makes sense to have a central solution because states individually are incapable of, because of those horizontal federalism issues that I talked about, are incapable of addressing the problem on its own. I mean, the state of Georgia can't regulate what goes on in the state of Alabama. That takes the central government, and that's a proper, federalism isn't just about coming out on the side of the federal government all the time or the states all the time. Federalism presupposes that there are some problems that are best addressed by central power. There's some problems that are best left to subnational power. And now the sort of where the rubber meets the road is sorting out which of those belong to which. But you can come out with different answers to that question and not be inconsistent. You can still be a supporter of federalism. And it doesn't mean that you have to side with the states of the federal government at the same time, nor does it mean you always have to subscribe to the sort of expansive view of either state or federal power.
Ladies and gentlemen, thank you all for coming. We would like to take a moment to thank many contributors, and please hold your applause until the end. Join me in extending special thanks to the Office of the President and Provost, the Office of Government and Community Relations, the School of Law, the Department of Political Science, the Center for Policy Studies, the Federalist Society at Case Western, the panelists, the 2016 Constitution Day Student Committee, and our advisors. At this time, you are all invited to join us upstairs to the Blackacre Lounge where refreshments will be served. Professor Denning and Professor Adler will join us to answer any questions which remain. Thank you all.